So welcome back, everybody, to our second panel on practitioners' perspectives on the international commercial courts. So we were very interested, but while we take stock, basically to see what practitioners thought about those courts and how effective they are in the dispute resolution processes, how their experience is with the use of those courts. And our panel is chaired by Chiann. Chiann is an arbitrator in Singapore, and she is very much involved with BIICL's work as well, in particular in the area of innovation in dispute resolution. So thank you very much, Chiann, for chairing this panel, and I hand over directly to you. Yes.
Thank you very much, Eva. It's a pleasure to be here with all of you today, virtually. I feel that Europe is doing quite well in terms of gathering, and it's nice to see more than one person, two people in the room together. We here in Asia are still awaiting that day. In any event, we have in panel 2 today experts who have been engaged in international commercial courts for some time, from various perspectives. And I think that it will be a very interesting from the Singapore International Commercial Court to the Paris International Commercial Court, and most recently the Netherlands International Commercial Court. With us today, we have Professor Anselmo Reyes and Barbara Rumora-Scheltema, as well as Daniel Schimmel. Professor Reyes practices as an arbitrator now. He was before that, he was a Hong Kong High Court judge from 2003 to 2012. Where he was in charge of the construction and arbitration list, a specialist list in Hong Kong, as well as the commercial and admiralty lists. He was the representative of the Hague Conference on Private International Law's Regional Office, Asia Pacific, from 2013 to 2017, and then he became an international judge of the Singapore International Commercial Court in 2015. So he brings together a range of diverse experiences as adjudicator and can give us advice as to what practitioners might be thinking about in relation to advocacy in the international commercial courts. Barbara is a litigator and a partner at the dispute resolution group at Nauta Dutilh in Amsterdam and co-leader of the firm's restructuring and insolvency teams. She was involved in the very first case of the Netherlands Commercial Court, and her practice ranges from restructuring and insolvency related litigation to enforcement, including enforcement of arbitral awards. Barbara has been involved in many high-profile cases, often leading to groundbreaking decisions by the Dutch and European courts. She has frequently acted as an expert on Dutch and Dutch Caribbean law issues for foreign courts, both in common law as well as civil law jurisdictions. And last but not least, we have Daniel Schimmel. Daniel is a partner at the Foley Hoag's International Litigation and Arbitration Department, resident in New York. It's awfully early for him, I think, today. He leads in the international arbitration and litigation practice of the Foley Hoag's New York office and has served as chair, sole arbitrator, co-arbitrator, emergency arbitrator, appellate arbitrator, and counsel in international arbitrations arising from a broad range of transactions. He also represents clients, including major French and other European groups, in international commercial litigation in the United States. He is a fellow of the Chartered Institute of Arbitrators and a member of the executive committee and a board member of the New York International Arbitration Center and a member of the arbitration committee of the New York City Bar Association. He is a co-author of an ebook which compares litigation in France, US, and China, which received the award for Best Law Book of the Year in France, and he is the author of articles on American litigation and international arbitration published in Le Monde and other publications. With that, I don't want to take up too much of my time, as we have excellent speakers here today, as you will have heard. And I'd like to now introduce in order of the founding of each of these international courts, with Anselmo Reyes, who is currently a judge with the Singapore International Commercial Court. Professor Reyes will speak on perceived problems of litigating before the SICC, focusing on enforcement of judgments, time efficiency, cost effectiveness, and proof of foreign law. Professor Reyes?
Thank you very much. I thank the BIICL for inviting me to speak on this panel. I'll address 4 perceived problems with litigating in the SICC. The first, the most commonly asked in relation to the SICC, is whether SICC judgments will be enforceable anywhere else. The Singapore is party to the Hague 2005 Choice of Court Agreements Convention. There's something like 32 countries that are party to that, 31 countries plus an REIO, a Regional Economic Integration Organization, the European Union. Singapore also has arrangements with a number of Commonwealth jurisdictions for the mutual enforcement and recognition of Singapore judgments. But the recognition of SICC judgments and Singapore judgments in general is far more than that, because in many common law jurisdictions, SICC judgments, Singapore judgments can simply be enforced through the ordinary summary judgment process. In most civil law jurisdictions, in many civil law jurisdictions, SICC judgments can be enforced under the civil procedure laws, rules of those civil law jurisdictions. Many civil law jurisdictions have modernized their civil law procedures, their codes of civil procedure, to enable foreign judgments to be finalized, provided to be recognized and enforced, provided those foreign judgments are final, provided they comply with international or indirect jurisdiction, provided that there is reciprocity, and reciprocity is often presumed, and finally, provided they are not contrary to public policy. The second perceived difficulty may be a question of costs. How much does it cost to litigate before the SICC? In principle, the winning party in litigation before the SICC will be entitled to its reasonable costs. So the measure of recovery for costs is similar to that in arbitration, except perhaps in one major respect. The SICC itself, the court, and its judges, one pays for that service, and the cost of the service is far lower than the cost, say, of 3 arbitrators, 3 commercial arbitrators. Those costs are available. The tariff for the SICC is available on its website, so you can see the costs there of the actual court services and the services from the judges, and you can compare that with the costs of arbitrators. Third, efficiency. In the previous panel, Professor Maniep noted that the average time for the resolution of an SICC case was 16.5 months. Now, I wish it were faster, and we're working on making it faster, especially with the implementation, probably later this year, of the SICC new rules of procedure. The SICC will have custom-built, bespoke rules of civil procedure. It will not just rely on Order 110 of the rules, current rules of court of Singapore, plus the rest of the Singapore White Book. It will have its own rules of procedure based on 3 tracks. A pleadings track, which will be more or less like an ordinary pleadings track at common law. A memorials track, which will be more or less like a memorial track in many civil law jurisdictions, and what might be regarded as a faster track, very similar to originating summons procedures today in common law jurisdictions, where there are not many factual questions in dispute, where there are questions of law primarily that have to be resolved. So in terms of costs, while the basic measure for recovery of costs is similar to arbitration, I would suggest that the SICC's costs are comparable and, in fact, more competitive than arbitration. Third, in terms of efficiency, I've dealt with efficiency. The last matter I'd like to deal with is the question of proof of foreign law. The SICC is both a common law and a civil law court. That means that you can prove foreign law simply by making submissions directly to the court on foreign law. The submissions will be made in English. It can be made by foreign lawyers registered to appear before the SICC. So this, I would suggest, would save much time and cost. One doesn't have to go through the full-blown common law procedure of proving a foreign law by expert evidence. One can simply rely on foreign lawyers appearing before the SICC. Thank you.
Thank you, Professor Reyes. Now we have Daniel Schimmel. Daniel will, I don't see him on screen, but probably right there. Hello, Daniel.
Good morning, good afternoon.
Good morning. Daniel will speak about the practical considerations that outside counsel and clients focus on when deciding whether to include the International Chambers of Paris courts in forum selection clauses versus other types of ADR. In the course of his discussion, we will also discuss length of proceedings, access to evidence, qualifications and expertise of judges, and also the ability to make oral arguments in English. Very practical. Daniel.
Thank you, Chiann. Thank you for your invitation, and I'm honored to participate in this panel. So I will speak about forum selection clauses and how easy or not easy it is to include the Paris International Chambers in forum selection clauses. And it starts with the fact that when an outside counsel like me speaks with a client about a draft forum selection clause, the discussion is very quick. It lasts at most a few minutes. The discussion is practical, and the client wants assurances that the proposed forum is going to satisfy certain basic international standards. And I believe there are about 6 international standards that are the most important. The first one is a dispute resolution process that is quick and efficient. The second is arbitrators or judges who are independent, who have expertise in resolving international business disputes and who pay attention to the facts and to the law. Third, reasonable access to evidence. Fourth, the fact that lawyers are bound by very strong, strict ethical standards. Fifth, flexibility in the dispute resolution process. And sixth, the ability to argue in English. Those are the 6 things that an outside counsel and a client look at in choosing a forum. So I'll say just a few words about each of them. In terms of a dispute resolution process that is quick and efficient, companies, whether they're big or small, cannot afford to be embroiled in arbitration and litigation for 2 years, for 3 years. We all know that business people, when the dispute arises, are eager to bring a case or to defend a case, but after a few months, after a year, they've moved on, and the time of litigation or arbitration is often different from the time of business. And the number of expedited arbitrations that have been brought everywhere, in Singapore, in New York, in Europe, over the last few years shows how important it is to resolve quickly and fairly international disputes. So Paris has been working to offer a dispute resolution process that is quick and efficient. The international chambers were created at the first instance were created many years ago, and I believe 1993, but the innovation was in 2018 when an appeals international chamber was created within the Paris Court of Appeal. And I understand that the time frame in the trial court is about 14 months, and the time frame on appeal, if there is an appeal, is again about 14 months. And what that means is that if a company is interested in a dispute resolution process that includes an appeal, Paris provides clear guidance about how much time it is going to take. So that's factor number one. Factor number two, arbitrators and judges who are independent, who are expert in resolving international disputes, who pay attention to the facts and the law. Arbitrators, many arbitrators are viewed as very credible and independent. The French judiciary is generally viewed as independent and competent. The question with respect to the French judiciary is how interested are they in the facts? And that's a question that has been raised often. And the International Chamber of the Paris Court of Appeal came up with an innovation to show that they are. In that international chamber, they adopted a protocol which borrows from the IBA rules on taking evidence in international arbitration. And what practically that means is that a party can ask for and obtain categories of documents, not just individual documents, but categories of documents, so long as they're sufficiently identified and obviously tied to the case. And that's a direct way to address the criticism or concern that French judges were not sufficiently interested in the fact. So that's factor two. Factor three, reasonable access to evidence. That means documents and witnesses. So documents, I just mentioned the ability to get categories of documents. And in terms of witnesses, there's the ability to cross-examine witnesses in open court. And in one of the very few judgments of the Paris International Chamber on Appeal, the court made very clear that it reached the decision that it reached after hearing the cross-examination of a key witness in open court. So there is reasonable ability to get access to evidence. Four, and it goes without saying, the need to have strong ethical standards. Five, a flexible process, and I understand that the protocol offers flexibility to litigants. Those of us who do arbitration know how flexibility is essential, that the process needs to be tailored to each particular dispute. And I understand that the Paris chambers work to offer this. And then finally, the ability to argue in English. The French judiciary, the French chambers have made a huge step forward. It's not a complete step forward by any means, but they've made a huge step forward by allowing lawyers to argue in English in court, to examine witnesses in English in court. That didn't really happen before 2018. It is a huge step forward. So pleadings still need to be made in French. They can be submitted with a translation, but it is a very important start. And I understand from judges in Paris that foreign lawyers, like lawyers based in the US, can actually argue in English in that court if they work in tandem with a French counsel. And that's also an important incentive. Many lawyers visit Paris to celebrate a wedding anniversary or to go on vacation. Now lawyers have the ability to say, I argued in English in the International Chamber, and that confers a level of prestige to the attorneys and makes it an incentive to select Paris in a forum selection clause. So those are the six basic international standards that companies look at. What I would say simply in conclusion is that the Paris International Chambers have showed that they are a viable option. especially for companies that do not want, for a reason or another, to resort to arbitration, and especially for companies that want the ability to appeal from a decision. There have been about 200 cases filed with the International Chamber in the Paris Court of Appeal since it was created, 200 cases filed, about 100 judgments. As was said before in this panel, some of these decisions address arbitration, but a bunch of these decisions address merit issues. And it shows that these international chambers have become a reality and are working to achieve international standards. Thank you.
Thank you very much, Daniel. Some very practical tips and actually grants French courts to the international community by way of the English aspect, which is very interesting. Next we have Barbara.
Yes, thank you very much, and thank you for inviting me.
Speaking, sorry.
Oh, I'm sorry. You fell away for a bit, so.
Yes, my internet. The NCC within the Dutch system. So over to you.
Okay, thank you again, and thank you for inviting me to the panel. I just learned that a reason to go to Paris might be for wedding anniversaries and the like. I'm sure there are very specific reasons why Americans like to come to Amsterdam, and that's usually not in connection with the NCC. But I will share my experience just as a practicing lawyer before the Netherlands Commercial Court, or the NCC. First of all, the NCC, as mentioned, was established in 2019. There are 3 instances dealing with civil law disputes in the Netherlands. The district courts, of which there are 7, and the 4 courts of appeal, and finally the Supreme Court in The Hague. The district courts and the courts of appeal judge on the facts, and the law Supreme Court only on matters of law. And the NCC was set up as a special chamber of the Amsterdam District Court and the Amsterdam Court of Appeal. So in principle, any case where the Amsterdam Court has jurisdiction could, if the parties so agree, be dealt with by the NCC in first and second instance. And you could then also continue with an appeal to the Dutch Supreme Court, but in that instance, the proceedings would not differ from any other Dutch regular commercial Supreme Court proceedings. Now, the main differences between the NCC and the normal court system is, of course, that the language of the proceedings is English, and this applies to the entire proceeding. So it's not just the language spoken at the hearing or at the witness hearings, but also the briefs and the judgment is in English. So if you search the court's website, you will find the decisions there in the English language. And another difference, which is relevant from a practitioner's point of view, is the court's flexibility. There are, of course, rules of procedures in place, but the court is also very open to adapting the rules if the parties request it. And finally, the court fees, and this was mentioned for other courts as well, are significantly higher than the court fees in the regular courts, but still, although this was the most controversial aspect when the law providing for the NCC was discussed in Dutch Parliament, court fees are still much lower than in some other jurisdictions. To give you an idea, the lowest court fee is for summary proceedings in first instance, that's 7,800 euros. And the highest tariff is for full proceedings on the merits on appeal, and that's 20,000 euros, and that's for the entire proceedings. Now, in the years before the NCC became operational, members for the pool of judges were recruited among experienced judges who spoke and wrote excellent English. So the NCC now has the best and brightest of our judges, who also speak better than average English. And they not only work as judges in NCC cases, but they deal with other complex commercial cases as well. And I should mention here that the number of NCC cases still have been relatively few. The Dutch rules of civil procedure apply, but there are some rules that apply specifically to proceedings before the NCC. Daniel mentioned rules concerning evidence. In principle, the Dutch rules of evidence also apply to NCC proceedings, but the parties may choose to approach taking of evidence and the kind of evidence that may be provided in a different manner, and the NCC will try to assist the parties in that sense. The most important requirement, of course, is that the court must ascertain in each case whether the parties have agreed to litigation before the NCC, that they have agreed that the proceedings are conducted in the English language, and that they have agreed to use the NCC's electronic portal for uploading and downloading briefs and communications. So the first case that was dealt with by the NCC was a case I was involved in. We initiated these proceedings just a few months into the existence, so in February 2019, and we had a decision on March the 8th, 2019. And this concerned enforcement of a share pledge. I represented the pledgee in that case, and our main consideration to take this case to the NCC was that we hoped for and expected a much shorter timeline than usual, because in this particular case, there were some specific circumstances that required very swift action. And this promise from the court was indeed kept. Normally, proceedings such as these in normal court take approximately 8 weeks, and we had our decision within 4 weeks. I must say that when going in, of course, this was the first case, so we didn't really know how this was going to turn out. And I feared that there would just be a bunch of Dutch lawyers pretending to be fluent in English, but failing miserably. But I must say I was pleasantly surprised in more than one way. First of all, the quality of the lawyers and their English was very good. The same goes to the judge who dealt with the case. He was a native speaker who had studied all of the briefs very much in detail before the hearing. He did a great job presiding over the hearing. And another important aspect was the flexibility. We received the mobile phone number of the NCC's clerk, and he made sure that everything ran smoothly and was dealt with in the most practical way. And finally, the decision was also written in a clear and accessible manner, with the judge explaining his train of thought. So from my experience, it was definitely a very positive experience. I should mention that the type of case that I handled in this particular case was one where interested parties may be invited to present their views. And under Dutch law, interested parties is a somewhat open concept. And depending on the circumstances, it can consist of just a few parties, but in some cases, it can be hundreds or even thousands. And of course, such interested parties will typically not have explicitly agreed to proceedings before the NCC, because they will not have been a party to the agreement to litigate before the NCC, either in the English language or otherwise. And in our case, there was indeed a party, an interested party who wanted to present their views on our application, but they had not agreed with the NCC as a forum beforehand. So the court, the judge made an effort to ensure that this party was fine with the NCC, and in particular was also fine with English as a language for the proceedings. As I mentioned, not many cases have been handled. So far, it's been about 10. My firm has been involved in 3 of those. all of the lawyers that I've spoken to who have been involved in these cases have been very positive. So we do advise our clients to at least consider bringing their case to the NCC. And I'm conscious you have some questions for me later, so I'll leave it at this for now, if that's okay. And I'm sure we'll go into why the NCC is attractive for clients or not later.
Great, thank you very much. Now I'm looking at multiple screens and I don't know where I'm looking, but I hope you can at least hear me, even though I'm not making good eye contact. In any event, we are now in the question and answer phase, and before we allow the panel or the audience to raise questions, and please do put your questions in the chat box. I do have a few questions for our panelists, and I'd like to start with Professor Reyes. The question is, to what extent, if at all, would interim measures ordered be your respective ICCs be enforceable in other jurisdictions?
Thank you very much. An interim measure ordered by the SICC, for instance, a freezing order, a worldwide freezing order, would not automatically be enforceable in other jurisdictions. The Hague Choice of Court Agreements Convention expressly excludes orders for interim measures. The civil procedure, the codes of civil procedure, the reformed codes of civil procedure in other jurisdictions likewise exclude interim measures because they require that a judgment to be enforceable will typically have to be final, and interim measures are, as their name denotes, simply interim. It's also unlikely in common law jurisdictions that one would be able to enforce interim measures by means of summary judgment in common law jurisdictions. So you will need the assistance of other jurisdictions in order to enforce an interim measure ordered by the SICC. Does that mean that it is, well, why bother? Why bother to have an international commercial court whose interim measures, a worldwide freezing order, would not be automatically enforceable? But I think you'd have that same situation with any court. And you'd have that same situation with an interim measure ordered by an arbitral tribunal. The New York Convention requires that an award be final, whereas, again, an interim measure is not. Many jurisdictions have provisions, legal provisions, Hong Kong is an example, that allow them to order interim measures in aid of foreign court proceedings or foreign arbitral proceedings. What going to the SICC does, where you have, let us say, a choice of court agreement designating the SICC as the court to deal with disputes arising out of an international commercial contract. What it does, if you apply for an interim measure before the SICC, it deals with whatever issues there are that are being raised by the other side against the grant of an interim measure. And once those are decided by the SICC, I would suggest at least give rise to an issue estoppel that will facilitate getting an ancillary measure from another jurisdiction easier. If you go to one jurisdiction to resolve whatever disputes there are as to whether or not an interim measure should be granted, that should make life easier in other jurisdictions where you seek to enforce the SICC's interim measure.
Great, thank you, Professor Reyes. And certainly it's good to also have the comparison of arbitration as well. And in fact, there's not much more benefit in that regard, other than, as you know, the Hong Kong-China arrangement that's quite recent and quite specific. Barbara, do you have any thoughts on this question?
Well, as I mentioned, the NCC is a special chamber of the Amsterdam court, and as such, it includes a court dealing with summary proceedings. And interim measures, of course, can be a whole range of measures, but it can also be injunctive relief or provisional measures, etc. And in the Dutch system, such orders would usually be made in summary proceedings. And in fact, most of the cases that the NCC has dealt with so far were before the court in summary proceedings. Several of them also included injunctive relief or provisional measures. And such decisions from the NCC are enforceable in the same manner that any other decision from a Dutch court would be. So the same considerations that Professor Reyes just mentioned as far as international treaties, cooperation, etc., are concerned, with one important exception, of course, and that is that in Europe we have the Brussels regime, which also makes it possible to enforce a summary judgment directly in all EU member states. And I would also mention in this context that one of the attractive thing, or one of the things to consider when you have a choice of which court to go to or which arbitration institute to go to, is enforcement, because it's of course very nice to have a great judgment, but if you can't enforce, you've spent a lot of money, but you still don't get what you want. So one of the reasons to choose for any type of court, in my view, would also need to include where would you need to enforce if the other party doesn't comply voluntarily. Thank you.
Thank you very much. Now let's move on to our next question, which relates to third parties wishing to join the respective your respective ICCs as a proper and necessary party, that is on the basis of subject matter jurisdiction. Now, to what extent, if at all again, would a judgment of the ICC against that third party be enforceable in other jurisdictions? Anselmo, would you like to start us off again?
Thank you. The SICC and other international commercial courts usually touts as one of its strengths the fact that it can deal with third-party situations. The court has a power to join the third party as a proper and necessary party to ongoing litigation, that is on the basis of subject matter jurisdiction. Arbitration doesn't deal easily with third parties who are not privy to an arbitration agreement. So if the third party appears and defends itself in third-party proceedings before the SICC, that's fine. One of the marks of international jurisdiction or indirect jurisdiction is submission to jurisdiction by appearing to defend the case. So if a third party appears to defend the case within the SICC, having been joined, then the judgment against that third party will be enforceable in other jurisdictions given indirect jurisdiction. What, however, about the third party that doesn't show up? The third party who says, come and get me in my own jurisdiction. I'm not going to cooperate. I'm not going to go to the SICC. I'm not privy to the choice of court agreement. Then there might be some difficulty because most civil procedure codes, and I believe the Hague Choice of Court Agreements Convention and the 2019 Hague Recognition of Civil and Commercial Judgments Convention does not recognize subject matter jurisdiction as a basis for the recognition and enforcement of foreign judgments. So there would be a difficulty there. However, again, going back to something that Barbara says, one of the important concerns about where you litigate before an international commercial court is where are the assets? And a place like Singapore, other places where they have established or are establishing international commercial courts will likely be major financial centers where companies, individuals, are likely to have assets either within the jurisdiction, banks within the jurisdiction, or passing through that jurisdiction, or somehow involved with banks or other concerns in that jurisdiction. So there are, notwithstanding, advantages, I think, to going to an international commercial court because of the court's ability to join third parties, willing or not.
Great, thank you very much. Let's move on then to the next question. It's been suggested in France that international commercial courts are like the fast track lane at the airport, if one can remember what an airport looks like. The perception is that if you have the means, then you can have your fast track court services. Otherwise, you will have to queue up like everyone else and wait your turn before the normal courts. Are ICCs then essentially just a commercial dispute resolution system for the rich? Daniel, let's start off with you here.
Well, thank you. I think the answer to the question when you speak with French judges is that first, if France wants to be credible and attract international litigation business, then it needs to satisfy international chambers. Companies have a choice; they can go somewhere else. So that's the first answer. The second answer is that French judges say that this strategy of pursuing international standards begins with the international chamber, but it doesn't end there. And the goal is to, over time, improve the litigation process in France generally, including by having a litigation process that's quick and efficient.
Thank you. And Barbara, what are your thoughts?
Thank you. Well, in my experience, and this may be different for different courts, but the choice is usually between the Dutch courts generally or the NCC, with alternatives being London, New York, arbitration. Now, those three last options are significantly more expensive. Not just court fees, but lawyers' fees also, and certainly in these complex international commercial cases, the interests are usually so high that these court fees aren't really an issue for most of the clients, in my experience.
Thank you, Barbara. And Anselmo, what are your thoughts on this?
This sort of perception has been a matter of concern for me, right or wrong, and I think it's a wrong perception, but the perception is there. My thinking is this: if you're an Asian party or parties based in Asia, then it's certainly more expensive, I would suggest, to go all the way to London or to Europe to have your dispute resolved. So it should be much cheaper to be able to go to an Asian jurisdiction, such as the Sicc, to resolve your dispute. But more generally, if you're a medium to micro, small, medium enterprise, I think that litigation before the Sicc would still be cost effective, whatever your means. It's not just for the rich, especially now. Building on what Sir Geoffrey Voss said in his opening speech, especially now that Sicc, other international commercial courts, have embraced remote technology. Singapore has been working on various iterations of e-litigation and continues to work on various iterations of e-litigation. So we're trying to digitalize as much as possible in order to enable litigation to take place without parties necessarily all having to fly somewhere to be in one place at one time, all at the same time for a long period. With the possibilities now raised by the use of remote technology, digitalization, and so on, I think this perception that the international commercial courts, the Sicc, and other courts are simply for the rich, that should go away. We should be able to increase access to justice in commercial disputes to a whole range of MSMEs.
Interesting to hear the technology being considered in the SICC. Certainly in arbitration, there is similar considerations. I guess it'll be a race to see who gets there first and who gets access to justice for its parties first. Moving on, next question is, it has been suggested in Australia that there is no need to create ICCs, as the same result can readily be obtained by establishing a commercial list or a commercial division with any ordinary court. Would there be any difference between a court with a commercial list and a full-blown ICC? Barbara, why don't we start off with you?
From the NCC perspective, I can be very short. There is no difference. The NCC really is both. As I explained, it's just part of the regular system. And from my perspective, on the basis of how the proceedings itself are conducted, except for speed, etc., and the outcome, I would not expect a different outcome from the NCC than I would from the regular commercial court. So I guess the answer to the question is, well, maybe.
Yes, we've certainly seen certain jurisdictions not explore the area of ICCs, perhaps because of the existence of a commercial list or otherwise. Daniel, let's kick off with you for the next question, which is, do ICCs need to have foreign judges?
So France has made it very clear by law that the responsibility, the role of judging belongs to nationals. There cannot be foreign judges on the Paris International Chambers. That said, it is obvious that the judges who are on these international chambers need to be credible, and it means that they need to project the image of a judiciary that's open to the world, and that means that they need to have frequent discussions with foreign judges to share experiences. It means that they need to be open to discussing with general counsel to understand their concerns and issues, again, because companies have a choice, and they should also be open to speaking to arbitrators and people in the international arbitration community to share ideas. And all of this is about sharing ideas. It's not about, judges being supervised by anybody. It's just a reflection that to be a good judge or to be a good arbitrator, you need to be willing to learn from others.
Thank you. And Anselmo, you might have a contrasting view.
Yes, perhaps I related to the previous question. Can you just have a commercial list? I was in charge of the commercial list in Hong Kong from 2008 to 2012 for 4 years. And during that period, the average caseload for the commercial list was 5 writs a month. That was the average caseload. And that's hardly enough. That's just the filing of writs. That's hardly enough to keep one judge occupied full time. And Hong Kong had a commercial list. Hong Kong is an international jurisdiction, but it's still difficult to attract international cases. So I think for young jurisdictions, it is essential to have foreign judges to signal that you mean business in terms of developing international commercial law and international commercial dispute resolution. For more established jurisdictions, such as the Paris courts or even the Netherlands courts, perhaps you don't need foreign judges. You can say, well, we have a long established reputation over 100 years of dealing with commercial cases. So we don't need foreign judges. We don't have to signal anything. Our history speaks for itself. For young jurisdictions such as Singapore, perhaps young jurisdictions such as Hong Kong, if Hong Kong should wish to have a more active commercial list, it would be necessary to give a signal. And I think that signal is given by having foreign commercial judges.
Great, thank you very much. And we have one last question, and this is directed at Barbara. What are the rules in relation to rights of audience for foreign lawyers in your respective ICCs?
Well, for the NCC, it is explicitly recognized and part of the NCC rules that foreign lawyers can apply for rights of audience with the NCC. And in fact, I think that in at least one of the cases that has been before the NCC, one of the parties' positions was argued by a London barrister. So that possibility obviously exists. It may be that for certain countries, the court will make some reservation because it has a very young bar, for example. But in principle, that is a possibility. And as long as there is, like in France, a tandem, there must be a local lawyer also involved. But the court is very open to English, American, French, Singaporean lawyers pleading the case on behalf of their clients.
Very good. Do any of the other speakers have any comments on this question? Otherwise, I think we have been asked to wrap up shortly. No other comments? Eva, over to you. Thank you very much for your excellent presentations.
Yes, thank you very much to everybody. I just wanted
Hello, Eva wanted to wrap up here in London, but then I think we lost connection somehow, but I'm still online from the same place, but you know how this goes. Thank you very much to all panelists, because we don't know exactly what you heard from Eva. It was a very interesting panel following up on the first one. We will now go into the break, which will last until 1:45 UK time. And you can break off the connection because the link will remain available. So it's not necessary you can, it is not necessary to stay online. Hope to see you back in the afternoon.